A defendant enters a guilty plea, hoping for probation to save him from prison. But in this courtroom, hope is a dangerous thing, and Judge Stephanie Boyd is about to explain why.
All right, and then this motion to seal, I am going to sign it. And this is supposed to, it's listed as defense copy, but this is the original.
Right.
So if you would like a copy.
I have a copy.
I may have accidentally put the sticker on there, Judge. Apologies.
No problem.
I gave you a copy as well, right?
Maybe I turned it in with the paperwork, maybe that's why. You had
Yeah,
it.
so it's in here and it was,
Is it attached to the
Should be put attached
vanilla
to the-
envelope?
no.
So that is
That
defense
was my.
copy.
All right.
So the original.
Oh,
is
let me
a-
write copy on that since I signed it.
The original should be attached to the envelope.
Here you go.
And so I did,
No problem. All right, thank you.
Judge, were you granting my request or?
No.
Thanks.
All right, counsel, have you received all discovery?
Yes, Judge.
And did you review it with your client?
It,
Court will find that the state is in compliance with discovery. Mr. Cambria, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
All right, you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to hold you over for trial. By entering this plea, you're giving up those rights. Did you understand?
Yes, Your Honor.
And your attorney has certain rights. He has from the presentation of the information, 2 days, and he also has 10 days to prepare for trial. By entering into this plea bargain agreement, you're giving up those rights. Did you understand?
Yes, Your Honor.
You're also giving up the right to have the information read to you. Do you understand that?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
yes, Your Honor.
All right. Then the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Let's see here. All right, to the clerk. I don't have the information. Let me see if I can find it. Just 1 second.
I have a copy here if you need one.
Ah, I see it. It's attached to a different document. All right, did you review the information with your attorney and understand it?
Yes, Your Honor.
Counsel, you weigh the reading of the information?
We do.
State, are you proceeding on the information as presented?
Yes, Your Honor.
Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
All right, based upon what you're charged with, the range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court would have granted your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
All right, off the record, can I have a file stamp, please? Plea.
Please.
Thank you.
The prosecution delivers a crushing blow. They are opposed to probation. Judge Boyd then reveals a terrifying math, a plea deal with a 10-year cap, but a revocation that could mean double that behind bars.
All right, we're back on the record. So that the record can be clear, the court called this case under a CM number. And the CM number was CM number 117167. And the case number in here, pre-indictment case number is 2025 CR 007438W. Those are the same cause numbers. Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he's confident in the plea.
All right. And do you believe he was sane at the time of the offense?
Yes,
Mr. Cabrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, my honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $5,000 fine. There's no application for community supervision. The state is opposed to your application for deferred adjudication. There's to be Chapter 62 compliance, and they reserve the right to request additional conditions if community supervision is granted. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
So you understand that the state is opposed to your receiving probation?
Yes, Your Honor.
And you understand that if the court were to give you probation, then the state is going to request perhaps additional conditions.
Yes, Your Honor.
And do you understand that ultimately, if the court were to grant your application for probation and the state were to make requests for conditions, it will be up to the court to decide whether or not to follow those conditions? Did you understand that?
Yes, Your Honor.
All right. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, no.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, Your Honor.
State any evidence.
Yes, Your Honor. The state offers States Exhibits 1 and attachments and States Exhibits 2 and attachments, and request, and I believe the court has signed the motion to seal pursuant to States Exhibit 2, Your Honor.
All right. And that order to seal has been signed, and I'm assuming you no objections to the court ordering that it be sealed.
No objection.
All right. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, we'll be back for sentencing. You're requesting a PSI?
Yes, Judge.
All right, we'll be back for sentencing on August 18th. The court will base its decision on whatever evidence that's presented. Do you understand?
Yes, Your Honor.
All right, if you'll confer with probation, and do you need a TAP evaluation as well or no? For your client?
I don't think so, Judge. I don't think there's any issue in that regard.
All right, so just the PSI probation. All right, thank you.
Thank you, Your Honor.
The atmosphere is thick with anticipation as Mr. Cambria stands before Judge Stephanie Boyd, ready to plead guilty. The goal is clear: deferred adjudication probation. But what unfolds is a masterclass in judicial realism that destroys any illusion of an easy escape. Judge Boyd proceeds with procedural rigor, securing the defendant's waiver of his right to a trial by jury. Then she shifts from process to profound warning. She lays bare the catastrophic range of punishment, 2 to 20 years in a state prison. She ensures he understands that the court is not bound by his plea agreement. But the true pivot point arrives when she reveals the state's position. The state is opposed to your receiving probation. This declaration turns the hearing from a negotiation into a confrontation. Judge Boyd doesn't just state the opposition, she weaponizes it as a lesson in accountability. She forces the defendant to acknowledge that if probation is granted, the state will push for stricter conditions. Most critically, she delivers the hammer blow. If he receives probation, violates it, and is brought back before her, she could sentence him to the full 20-year maximum. Her questions are not mere formalities. They are landmines she makes him step over, ensuring he feels the tremors of his potential future. The guilty plea is entered, and evidence is accepted under seal, adding a layer of mystery to the charges. Judge Boyd, in a move that heightens the suspense, orders a pre-sentencing investigation, PSI, and sets a sentencing date for August 18th. She has deferred a finding of guilt, but she has not deferred a lesson in consequence. The defendant leaves not with reassurance, but with the grim understanding that his freedom now hangs by the thinnest of threads, with Judge Boyd holding the shears. This hearing is a powerful depiction of justice as a high-stakes warning, delivered with unwavering authority.